Good morning, Dan and Amy. Andy McCarthy, former Chief Assistant U.S. Attorney in Manhattan, Southern District of New York. Much in the news these past many months.
Yeah, I saw him last night on Special Report.
He's also contributing editor at National Review and author of I think it's a New York Times bestseller. If not, it should be. Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. He joins us now. Andy, thanks for being with us. Appreciate it.
Good morning. It is a New York Times bestseller, and it's my mother insists it's the only thing that's true in the New York Times, but she's sure it's true.
Very good. So you wrote a piece in advance of this momentous day about impeachment generally, and I thought, as usual, a salient point. If this was serious, if this case was substantial, then you wouldn't have the need or the time for the sort of gamesmanship and showmanship that House and Senate Democrats have engaged in.
Yeah, Dan, I think that's right. I mean, you grow up for a long time with how best to explain this to people, and that's part of the problem, right? If we had a real impeachable offense, you'd be able to explain it to someone in 2 seconds, but the Democrats couldn't even settle on what their theory was for what Trump did. You know, they kind of careened from, bribery to extortion to campaign finance to quid pro quo, and then they finally settled on abuse of power, which is a pretty amorphous and vague standard. But I think that all goes to the point that think about how different this would look if you really had an impeachable offense, which is to say if you really had something that had so convinced the public that the president needs to be removed that it would have put political pressure on 2/3 of the Senate to oust him. Something like, for example, if Bob Mueller had actually proved that Trump was an agent of the Kremlin, then I think we wouldn't even be starting a trial today. I don't think he would have been able to survive that. So, I think it's helpful to think about how different this would look if we were actually dealing with something that everybody could agree was impeachable.
So in the Clinton case, evidence was admitted automatically. Here they're going to vote, the senators are going to vote to admit any documents. Why the difference?
I think that they're drawing a distinction between the documents that came into the House's investigation and any new documents that they're talking about. I don't think they're going to actually have any difficulty getting into the record anything that the House already considered. Here we have an issue that we didn't have in the Clinton case, which is the Clinton case was the result of a lengthy, thoroughgoing investigation by a special counsel that Congress essentially adopted in the House. And there was a big argument then about whether what Clinton did was egregious enough and connected enough to his responsibilities as president to be impeachable, but nobody had any doubt about the fact that he did it and that it was wrong. Here, the distinction we have is that the House did a very shoddy, rushed investigation, provided the Senate with 2 half-baked articles of impeachment, and now what Democrats are trying to do, coordinating between the House leadership and the Democrats in the Senate, is try to get the Senate to finish the investigation that the House didn't complete. And the Republicans' position, of course, is that it's the House's job to do the investigation, and the Senate only tries whatever product the House gives them. It's not the Senate's job to continue and complete the investigation. So for this reason, they're having a big to-do over what documents and testimony already came out in the House versus what new stuff are they looking for. But I think with respect to the stuff that already came out in the House, it'll be very pro forma, and that will come right into the Senate trial. In fact, they've already been arguing about it in these lengthy submissions that they've made.
Chief Justice John Roberts presides over this trial. Where is he going to be material in the trial?
I think quite possibly not at all. It sounds like a very important position to be presiding over the impeachment trial. But in point of fact, it's probably more ornamental than substantive. And what I mean by that is the Constitution makes the Senate wholly in charge of impeachment. And the only reason the Chief Justice presides is because the normal presiding officer over the Senate is the Vice President, but the framers understood that it would be unseemly to have the Vice President preside over a presidential impeachment when the Vice President would become President if the President was removed. So they tried to solve that problem by having the Chief Justice of the United States be the presiding officer, but his basic job is to keep the trains moving on time and to enforce the regulations that the Senate imposes on its proceedings. And if he does anything that a majority of the Senate disagrees with, they can overrule him. So I think, given Roberts' personality, which is to try to not make waves, and I saw the New York, I think it was the Wall Street Journal, describes him as an incrementalist, if I'm remembering. I apologize to the Journal if I'm attributing it to them and it was somebody else, but I think it was an accurate description of Roberts. He doesn't want the court or himself, I think, to be perceived as making earth-shattering decisions, because he doesn't think that's the court's role in American life. This is for the Senate to do, and I think he's going to make sure it appears and is in substance the Senate acting, not Roberts acting.
From the briefs that have been filed from both parties, is there anything new that we might anticipate as we move into the arguments from each side?
I think there's nothing new. To me, the interesting dynamic is two things. One is witnesses, and one is the president's position. What you're probably going to hear today, Dan, is a lot of back and forth about new witnesses and new documentary evidence. McConnell wants to defer all that till the end, virtually when they're deliberating a verdict. The Democrats obviously want to take the position that if the new witnesses and documents are relevant, which is why they say they're asking for them, they should be part of the narrative that the House impeachment managers are presenting to the Senate, and therefore they should be incorporated into the mix earlier on. They shouldn't wait till the end. I think the Republicans have the votes to say to them, look, if the witnesses were so important, then the House would have made more effort to get them. They didn't, so we're going to defer consideration of this, and you should count yourself lucky that we're deferring consideration of it, because since it wasn't part of the House proceedings, maybe we wouldn't have to consider it at all. So that'll be today's debate. And the other thing I think is interesting in the president's papers is it looks to me like there's a division of opinion in the president's camp about how they want to handle this. I think the lawyers want to take the position that on their face, these articles of impeachment are woefully inadequate constitutionally, and they should just be quickly flushed. That is, there should be a quick acquittal vote without the need to take new evidence. And that takes up about 2/3 of the president's team's trial submission. But then the last third, it looks like they go the other way, and the president wants a trial because he wants to be vindicated. So they make an argument on the facts, which I think the lawyers, they say there's no quid pro quo and the president didn't do anything wrong. There was no inappropriate action. They give a kind of a skewed version of what Ambassador Sondland's testimony was like, what it was about in the House. And I think there it looks like the president wants to be vindicated on the facts of the case. And the problem with that is if you take on the facts, that increases or betters the Democrats' case that they need more evidence. That is, if the president wants to put an issue, whether he did anything inappropriate or whether there was a quid pro quo, the Democrats are in a stronger position to say, see, we need these witnesses because they can speak to these issues that the president himself is emphasizing.
Right, but I mean, they're sort of arguing the alternative, right? It's half legal and half political. And so this seems to me what President Trump has said previously, which is, sure, let's everybody testify. Sure, Bolton's can say whatever he wants, Mulvaney, and then we'll call witnesses, and I'll be completely exonerated and vindicated. I want to spike the football and really punish House Democrats for this quote unquote hoax, as he has said repeatedly. And, I wonder if this is so much like, let's include this because this is all the, you want to fight, I'll fight. And then you tell your friends, hold me back, right? I don't really want to fight, but I want to take the public position that I'm not afraid of anything. And I want everything to come out because I'll be exonerated. But I'm happy just to have this thing set aside based on the House Democrats failing to meet the evidentiary standard.
Yeah, look, I think there's a lot of that going on. And I think Trump is shrewd enough to understand that the Democrats don't have any belief or expectation that the president is going to be removed in the impeachment trial, right? That's not their objective because it's not going to happen. There's no way 20 Republicans are going to vote to remove the president. So what are they trying to accomplish here? What this has always been about, I think, is bruising him up, that is the president, for the 2020 election. And from the Democrat standpoint, then, the longer this goes on, the better it is for them. Because even if the president isn't going to be impeached, the information that would come out in the trial is not going to cast him in a favorable light. You could say, well, but they're putting a lot of risk on, say, Biden, because if there are witnesses and the president is going to insist on testimony from one or both of the Bidens, I think the Democrats factored that into the mix when they decided to go down this road, and they've either decided it won't destroy Biden's candidacy or they're willing to run that risk for what they perceive as the greater good of a chaotic proceeding that could bruise Trump up. So I think that's their calculation. And McConnell sees this too. And McConnell, I think, for that reason, is putting the pedal to the metal here and is trying to get this thing over with ASAP.
Yeah, leave the Democrats shadow boxing, right? Never get into the ring. He is Andy McCarthy, former Chief Assistant U.S. Attorney, Southern District of New York, contributing editor to National Review, and author of the New York Times bestseller, Ball of Collusion, The Plot to Rig an Election, Destroy a Presidency. Andy, thanks for joining us. Appreciate it.
Thanks. You guys have a great day.
You too. And he joined us on our turnkey.pro answer line.
The stories you need to know to start your day. This is Chicago's Morning Answer on AM 560. The Answer.